Hello everyone, welcome back to the MCQ series of the Law of Contract. Here we will be again continuing the MCQ series of the Contract Act. Now let us start from the question number 76. Which of the following is an exception to the rule of doctrine of privity of contract that a stranger to a contract cannot sue? Options are family settlement, mortgage agency, both A and C. Here correct answer is option A, that is family settlement. Question number 77. Exceptions to the doctrine of privity of contract do not include option A, beneficiaries under a charge, option B, equitable mortgage, option C, estoppel, and option D, marriage settlement. Correct answer here is option B, that is equitable mortgage. Question number 78. The acceptance given by A on B's invitation for lunch over a phone is not a contract because of which of the following? Option A, the acceptance was given orally. Option B, the parties did not talk face to face. Option C, there is no intention to create legal obligation. And option D, invitation cannot be proved in the court of law. Here correct answer is option C, that is there is no intention to create legal obligation. Question number 79. Which one of the following is essential for a valid contract under the Indian Contract Act 1872? Option A, meeting of minds of the parties. Option B, meeting of the parties for searching legality of rights. C, meeting of the parties to discuss consideration. And D, meeting of the parties to discuss proposal and acceptance. Correct answer here is option A, that is meeting of minds of the parties. Question number 80. Which is correct? Proposal plus acceptance is equal to promise. Promise plus consideration is equal to agreement. Agreement plus enforceability is equal to contract. And option D, all of the above. Correct answer here is option D, that is all of the above. All the above given options are the correct options. Question number 81. Which one of the following essentials contract does not find place in the Indian Contract Act 1872? Option A, competency of parties, real consideration, intention of contract, and lawful object. Here correct answer is option C, that is intention of contract does not find place in the Indian Contract Act 1872. Now let us proceed to question number 82. Difference between a contract and social agreement is that of consideration, intention to create legal relationship, consensus, addendum, certainty of performance. Correct answer here is option B, that is intention to create legal relationship is the main difference between the contract and the social agreement. Question number 83. The test of intention to a contract is objective, subjective, depends on case, none of the above. Correct answer here is option A, that is objective. The test of intention of the contract is objective. Question number 84. The correct sequence in the formation of a contract is offer, consideration, acceptance, agreement, agreement, consideration, offer, acceptance, agreement, consideration, offer, acceptance, consideration, agreement. Correct answer here is option C, that is offer, acceptance, agreement, consideration. Question number 85. A unilateral contract in which only one party is bound is also known as facet contract, implied contract, executed contract, executory contract. Correct answer is option C, that is executed contract. Question number 86. The words not defined in the Specific Relief Act shall be understood according to the Indian Contract Act, the Indian Succession Act, Transfer Property Act, none of the above. Correct answer here is option A, that is the Indian Contract Act. The words not defined in the Specific Relief Act shall be understood with according to the Indian Contract Act. Question number 87. A standard form of contract is one in which the terms are fixed by the government to the state to which the contracting party belongs. B, the terms are predetermined by the custom of the trade to which the contracting party belongs. C, the terms on which the mercantile transactions of the common occurrence are to be carried out. And D, the terms are fixed by one of the parties in advance and open to acceptance by anyone. Here in question number 87, correct answer is option D. The terms are fixed by one of the parties in advance and open to acceptance by anyone. Question number 88. Standard form of contract is also known as contract of adhesion, unilateral contract, specific contract, both A and B. Correct answer here is option D, that is both A and B, adhesion and unilateral contract. Question number 89. Contracts of adhesion are unfair contracts, unlawful contracts, contracts of adults, standard form of contracts. Here in question number 89, correct answer is option D, that is standard form of contracts. Question number 90. Which contract is specifically enforceable? Option A, contract by B to deliver a lecture of law at Jabalpur University, contract of marriage, contract by B with A to supply goods as of when A requires, and option D, none of these. Here correct answer is option D, that is none of these are specifically enforceable. Question number 91. Match the following. McGregor versus McGregor. Here the correct match will be intention to contract. And Weeks versus tabloid. Correct answer will be general proposal. And Henderson versus Stevenson, correct answer will be reasonable notice. And Curie versus Misa, the correct match is consideration. By going through these matches, correct match here will be option B. Question number 92. Which one of the following is not provided in section 4 of the Contract Act 1872? Options are communication of a proposal, communication of acceptance, communication of revocation, revocation of proposal and acceptance. Here correct answer is option D. Revocation of proposal and acceptance is not provided, whereas communication of proposal, acceptance and revocation are provided. Question number 93. Which one of the following is not provided in the section 4 and 5 of the Contract Act? Option A, communication of offer, communication of acceptance, revocation of proposal and acceptance, and D, revocation of contract. Here in question number 93, correct answer is option D. Revocation of contract is not provided in section 4 and 5 of the Contract Act. Now let us proceed to question number 94. Which of the following is a leading case on the point of a communication of offer? Carlyle versus Carbolic, Smokeball Company, Balfour versus Welford, Taylor versus Porrington, and D, 𝐲𝐼 versus Ghori-Datta. Here correct answer is option D. 𝐲𝐼 versus Ghori-Datta is a leading case on the point of communication to offer. Question number 95. A proposes by a letter sent by post to sell his house to B. When is the last point of time when A can revoke the proposal? Option A, before the date or time when A posts the letter, before the date or time when B receives the letter, C, before the date or time when B posts his letter accepting the proposal, and D, before the date or time when A receives the letter of acceptance sent by B. Here in question 95, correct answer is option C, when the date or time when B posts his letter accepting the proposal. Question number 96. In which of the following cases a proposal can be revoked when it is made by post? Option A, before the promisee posts his letter to acceptance, B, till the letter of acceptance reaches the promisor, C, till the promisee receives the acknowledgement that the letter of acceptance has been delivered to the promisor, and D, proposal once made cannot be revoked. Here in question number 96, correct answer is option A, before the promisee posts his letter of acceptance. Question number 97. A revokes his proposal made to B by a telegram. Under section 4 of the Indian Contract Act 1872, the revocation is complete as against A when the telegram is option A, received by B, option B, dispatched by A, option C, both A and B, and option D, none of the above. Correct answer here is option B, that is dispatched by A. Question number 98. In case of acceptance by post, at what point the acceptance is complete as against the proposer? Option A, when the letter of acceptance is put in the course of the transmission so as to be out of power of the acceptor, when the letter of acceptance has been written, when the letter of acceptance has been received, when the letter of acceptance has been read by the proposer. Here in question number 98, correct answer is option A, when the letter of acceptance is put in the course of transmission so as to be out of the power of the acceptor. Question number 99. Acceptance is sent through post. Option A, cannot be revoked at all, can be revoked at any time, can be revoked only if it does not reach the offer, and D, can be revoked before it comes to the knowledge of the offerer. Here in question number 99, correct answer is option D, that is can be revoked before it comes to the knowledge of the offerer. Question number 100. A proposes by letter to sell a house to B at a certain price. The communication of proposal is complete when A posts the letter, A has completed the writing of the letter, A gets information about the posting of the letter, and option D, B receives the letter. Correct answer here is option D, that is B receives the letter.